right. Well, welcome everyone. Thank you so much for joining our webinar today. I'm Elizabeth Long. This is Zia Sumar. For those of you who don't already know us, we're lawyers practicing in Toronto at LM Law Group. We're immigration lawyers in Canada. And today we wanted to go over all of the crazy changes that have been happening with the work permit system. So now just some logistics before. This is being recorded and we will be sending the recording out to all registrants. What's going to happen is we're going to have a presentation for, I'd say, it'll take around half an hour. And then afterwards, we're going to open it up to questions from you from the audience. If you have any questions, please put them in the Q&A button and we will try to answer as many questions as we can. All right, here we go. All right, so let's get started.
Perfect. So the first change that we want to talk about today is with regards to labor market impact assessments. So when we're talking about LMIAs, when you're looking at processing them, you need to know first what category the LMIA falls under. And so the way we do that is we look at what the salary is of the position that's being offered, and we compare that to the provincial wage thresholds. Now, if it falls above the provincial wage threshold for the province, then you're looking at a high wage. If it falls below, then you're looking at a low wage LMIA. Now, last year with low wage LMIAs, Service Canada has stopped processing. So now there's a refusal to process in place for low wage LMIAs in areas where the unemployment rate is over 6%. So that's what we see basically is online. There's now you can go online and check to see what the unemployment rate is in each region. And so for any regions that fall above that 6%, Service Canada is not processing LMIAs for those particular low wage LMIAs for those particular regions.
And Zia, when you look at regions like Toronto, Vancouver, Calgary,
they're all part.
all of the large centers have unemployment rate of over 6% these days, right?
Mm-hmm. Yeah. And these are only being reviewed, I think, every 3 months. So we're not going to see another update now until we just had an update January 10th, if I'm not mistaken, and we'll see another one now in April. So basically everything that's been identified as over 6% is going to be in place. That restriction for low wage LMIs is going to be there till at least April now. And also last year, when we are talking about these provincial, the median wages for determining if it falls under low wage or high wage, there was actually a huge increase. It was a 20% increase last year in terms of what the differentiating factor was for high wage versus low wage. So, before in Ontario, the threshold was just over $28, and now it's at $34 an hour. So huge increase in terms of who now falls under high wage versus low wage. With this low wage refusal to process, there are certain exceptions. So depending on the occupation, the LMIA might still be able to be processed. And so if the occupation falls under construction, food manufacturing, healthcare, primary agriculture, these are all exceptions to the low wage ban. So even if it's a low wage LMIA and the location of employment is within one of the areas where the unemployment rate is over the 6% threshold, you can still process the LMIA. There's also an exception for LMIAs that are being submitted just to support permanent residents. And we'll talk about arranged employment and how all of that works later in a couple minutes. But certainly right now, if you are applying for an LMIA only for the purposes of permanent residence, so not to get a work permit, there won't be a work permit attached to it, then you can still process it even if it falls under this refusal to process. The other big change with LMIAs that we saw is in terms of documents. So one part of an LMIA application is, of course, submitting the right documentation. And part of what Service Canada is looking for is to see that it's a legitimate business and that the business is able to financially support the salary that's being offered in the LMIA application. And the way that they were doing that before, there was a variety of documents that we could provide on an LMIA application. Like tax documents, for example, you could provide before attestations by professional accountants. Service Canada is now, unfortunately, no longer accepting these attestations from CPAs, and basically they've changed it to say that the only document, aside from tax documents, is the attestation from a bank. What we're seeing, having spoken to many of the banks, and the large banks especially, are saying that they're not providing these attestations. And so essentially what that means is that providing the supporting documents that Service Canada is looking for, that officers are looking for in order to show the financial capacity, has become increasingly difficult. And the reason that we see that this comes up is, many companies are, you may be a startup, you might be investing uh, the revenue back in, and so what's being demonstrated as revenue and retained earnings in the tax documents may not support the salary, but the reality is that there would not be an issue in supporting paying the salary of the employee that you're looking for. And so that's where we're seeing this come up quite a bit. The ways around it in terms of alternative documents right now is, well, one, if the company is exempt from having to provide the business legitimacy documents, and that comes up if you have an LMI, if your most recent LMIA that you've submitted was approved and it was within the past 2 years, then you don't need to worry about the business legitimacy documents. And then the other part is if the employee that you're applying for with the LMIA is already working for you, then Service Canada will accept 6 weeks of payroll statements instead of the tax documents or the attestation. So important changes to the LMIA that we've seen over the last couple months, and certainly have made it a little bit more difficult to go through LMIAs.
And so, Zia, some of the difficulties we've seen are even large organizations uh, overseas, US companies that have subsidiaries in Canada. The subsidiary isn't really earning
Yes.
much money. And before, common sense, we were able to get CPAs to attest to say, yes, the company does have the funds. These days, we can't do that. The banks won't issue the letters, and so it's all about the tax documents in the last fiscal year. Okay, so those are some of the difficulties. Now let's talk about other work permit changes. One of the big ones we did see was a change to the intra-company transferee work permits. So first of all, the salaries of senior executive managers now need to meet median wage. Before it was just the specialized knowledge workers, now the managers do as well. The other thing that we are seeing, and this was directly targeted towards businesses that are going to create new subsidiaries in Canada, um, was that the government now restricts ICTs to businesses that already have two revenue generating operations. Before, when they just came out, it was very confusing and it said two revenue generating operations outside of Canada. They have clarified that now to say if you already have a revenue generating operation in Canada, that can equal to one of the operations. So that's fine. But if you don't already have a revenue generating operation in Canada, to qualify for this, you would have to have two other generating businesses in 2 different countries outside of Canada. Then we also see post-grad work permits now being restricted. So for those people who now have submitted their study permits after November 1st of last year, most people right now who are graduating now would have likely submitted their study permits before this date. But you're going to see coming up, later this year and afterwards, many students, if they submitted their study permit after November 1st, they would not be able to obtain a post-grad work permit if they graduated from a non-degree program, let's say a college program, or even in universities, there are non-degree programs. And those programs, they have to be in the field of study. So there's a whole list. We've put the link here. By the way, we'll send out these slides to everyone who have registered, so you'll get that. But if you click on this link, it shows the field of studies for the different programs where if you graduate from a non-degree program, you can actually get the post-grad work permit. If you don't, and it's non-degree, and you applied for your study permit after November 1st of last year, you would no longer be eligible for the post-grad work permit. And then we also have the international experience class. The government made an announcement on December 18th that the international experience class work permits are going to be issued under another provision of the Act. Why is this significant? It's because previously, the work permits, especially the young professionals work permits, the ones where they have um, a, a specific job offer and they qualify for the work permit based on that, they were able to get arranged employment points. Under the new classification, they would not be eligible for the arranged employment points. And we'll talk about arranged employment, I promise, afterwards.
All right, let's look at some of the changes last week in terms of work permits for family members. So previously, for family members, we were able to get open work permits based on the foreign workers work permit here in Canada. But starting January 21st, these work permits are now being restricted in terms of who is eligible for them. So for an individual on a work permit right now, what we're looking at is what their occupation is here in Canada. So if they're working in any tier 0 or 1 occupation and they hold a work permit that's valid for at least 16 months on the day that the spouse applies for their spousal open work permit, then that's fine. The spouse is eligible for the spousal open work permit. If the work permit is valid for less than the 16 months, then we see an issue, even if they're working in a tier 0 or 1 occupation. For tiers 2 and 3, IRCC has an occupation list. So previously, while all occupations that fell under tiers 2 and 3 were eligible, now IRCC has a list of occupations that are going to be eligible for the open spousal work permit. And again, here, the principal applicant has to hold a work permit that's valid for at least 16 months on the day that the spouse is applying for the open spousal work permit. So what we're seeing is basically a limitation in terms of when the spousal open work permits are, who is eligible for them and when they'll be issued. Now, of course, like anything else, there are exceptions to this as well. So if the principal applicant has a work permit through a free trade agreement, and if the free trade agreement has provisions for the spousal open work permit, then the spouse can still apply through the free trade provisions. So we're not talking about the general spousal open work permit provisions. We're talking about where the free trade agreement specifically provides for spousal open work permits. There's also exceptions for when the principal applicant has a work permit that's been issued based on having applied for permanent residence through an economic program. So as long as the principal applicant has a work permit that's valid for at least 6 months when the spouse is filing for the open work permit, then the spouse can apply for their spousal open work permit. Now, here we're also seeing family members, so dependent children, are also eligible now, are still also eligible for their work permits. But this is before where we could see it for any principal applicant and their family members. Now it's limited only if they've got a work permit through the permanent residence programs. There's also a short exemption for extension applications. So if someone is here in Canada on an open spousal work permit, and that open spousal work permit was issued for a shorter duration than the principal applicant's work permit, regardless of what occupation the principal applicant is working in, or regardless of how long the principal applicant's work permit has till expiry, the spouse can still apply for the spousal open work permit for the time being.
Okay, so let's go to the pause on arranged employment points. So just before Christmas, December 23rd, the minister announced that they intend to pause on being able to use arranged employment points for express entry in spring of this year. We don't know when spring actually is. Sometimes spring means summer or fall. And who knows what's going to happen then. But let me just sort of go into, first of all, explain for those of you who don't know what exactly arranged employment means. Arranged employment is essentially you can get 50 or 200 points for express entry, depending on the kind of position that you have. And how you get that is, first of all, you have to have a job offer from a Canadian employer that's high skilled. And the job offer must last for at least a year after you get your permanent residence. So normally if express entry takes 6 months or a year, you'll want to get a job offer that's either permanent or at least, let's say, year and a half or 2 years. Okay, fine, great. What else do you have to have? You also have to have either a LMIA or a LMIA work permit. What's the difference between just a LMIA or a LMIA work permit? Well, first you get the LMIA and then you can apply for the work permit. Some people, the LMIA, they don't have a work permit, but they have an LMIA that has not expired yet. That can give you in and of itself the arranged employment points. Or if you have the LMIA has the validity date has expired, but you obtained a work permit based on the LMIA, that's fine as well. Okay. Or if you have an employer-specific LMIA exempt work permit, we call those the International Mobility Program, IMP. This is where the employer didn't have to file the LMIA. Instead, they filed an offer of employment for you. And if you have those kind of work permits, you don't get it right away when you get a work permit. You have to have worked for the employer for a year before you can get arranged employment points. Okay, so given the fact that right now the points are so competitive, it's well above 500. These arranged employment points can really give those people who fall under this category an edge to actually be invited to apply. So if you do fall into this category, I highly, highly recommend that you come and speak with us and we see whether or not we can put you into the pool right now and you can take advantage of having those elevated points, because come spring of this year, if the minister is still in power, then this advantage could be taken away. Okay. Why did I put a question mark behind it? Well, because we are likely going to have an election come March. And if this minister doesn't announce it um, before he leaves the office, then it remains to be seen whether the next minister would actually enforce this.
So flagpoling, this was another one of the big changes. I feel like there's always something coming up with IRCC. So what is flagpoling? Well, flagpoling is where a temporary resident who was in Canada leaves Canada and re-enters simply for the purposes of accessing immigration services at the port of entry. So someone who is in Canada, for example, on a work permit, study permit, visitor, they are exiting Canada, re-entering by only having gone to the United States or St. Pierre and Miquelon, and on their re-entry, they're applying for a work permit or a study permit. So what has happened is that IRCC has ended flagpoling for the majority of situations. And this includes people who are both applying at or who are trying to flagpole both at land borders and at airports. So even for someone who is taking a flight over to the States for a weekend, wants to come back, and is applying for a work permit on their re-entry to Canada, IRCC and CBCA is taking the position now that that is still flagpoling, and they will not process the application. So what that means is that basically what you're looking for, what you're looking for, and Elizabeth is going to talk about this in a bit, is how you're what you need to consider is how you're applying for work permits and how you're applying for study permits. And the reason that flagpoling was such a benefit was because, with the current processing times online, people were waiting quite a long time to get decisions and to get their work permits. And so being able to flagpole and get your permits at the borders, at the airports, just meant getting decisions much quicker and without having to worry about forms and certain documents. So certainly there was a huge benefit for being able to flagpole, but as of now, the process of flagpoling has been stopped. And this also includes not just people who are applying for permits, but for people who have applied from outside of, they've submitted their applications online, considered to be an outside of Canada application. And so you have what's called your introduction letter, and you have to go pick up your physical permit at the border. That also is being considered to be flagpoling. And so that's also not being processed right now. There are, of course, and like anything else I've talked about today, there are also exceptions to this as well. So if you're an American citizen or permanent resident, you're still able to flagpole. If you're applying through the free trade agreements for professionals or technicians with the US-Mexico Free Trade Agreement, Chile, Panama, Peru, Colombia, South Korea, all of these free trade agreements specifically for professionals and technicians categories are still exempt. Spouses of free trade agreements through Panama, Colombia, and South Korea also exempt. And anyone with pre-existing appointments with CBSA are also still able to flagpole.
Great. So what do you do? What do you do if you can't flagpole? Unfortunately, for a lot of people, that would mean a longer processing time. Um, inside Canada. Now, if you currently hold a work permit or study permit, you are able to apply inside Canada, where the CPC Edmonton would be processing your application. Okay. And one of the main things that you need to understand is you may be able to work based on implied status, but do not leave Canada if you're on implied status. What is implied status? It's if you applied for your work, let's say you have a work permit and you're applying to extend it, okay? If you apply for your extension before your work permit expires, you have the legal right to continue to work in Canada, even if the first work permit has expired before you get your decision. That's called implied status. Now, the problem with this is if you need to leave Canada, you cannot come back to Canada and still expect that you would have implied status. Even if you have a visa, or even if you're visa exempt, you can enter the country, that implied status breaks when you leave Canada, and you wouldn't be able to work until the new work permit is issued, okay? Now, there is still an expedited processing if you're changing jobs and both work permits are employer-specific work permits. We can ask for expedited processing, but it's not necessarily for sure it's going to be issued. You don't really control that time, and it's a very specific situation. Okay, so if you're applying inside Canada, don't leave until you get your new work permit if you're on implied status. Now, the other option is you could specify. When I say we are going to apply at a visa post, it doesn't mean that you go yourself to the visa post. We apply online as well, but the forms are different. And the processing is normally different. It's processed, for example, if you are in Canada, it will be processed in New York, okay? But the thing is that number one, you don't have implied status when you are applying to the New York visa post. So if your work permit is going to expire, you cannot then just stay in Canada on implied status because you've submitted the application. Okay. And recently, IRCC now no longer allows people who only have visitor status to apply inside Canada for the work permit. You have to, if you only have visitor status, you don't have a work permit or study permit, you can't apply for an extension or work permit inside Canada. You have to apply to the visa post. The other issue about this is if you're going to apply at a visa post, your work permit, great. It's approved. Fantastic. But you don't actually have the work permit in hand. You do have to leave the country and then come back. And before, we would send people to the border. You drive to the border. They didn't even count that as flagpoling. They said, well, if it's been approved, it's not counted as flagpoling. You can even activate it anytime outside. For example, Niagara, they had restrictions on hours for flagpoling. You could activated it outside of those hours. However, I called Niagara and they said, no, now this flagpoling includes the activation of the work permit. So what does that mean? That means for a lot of people, if you have it activated, if you have the approval, it's in Canada, you're going to have to travel outside of the US and come back. I'm actually talking to a travel agent to see if we can get people on a cheap flight to Cuba, stay there for a day or two, and then come back and activate the work permit or something like that. And somewhere cheap, somewhere, any country, it doesn't matter which country, as long as you have a visa to go there and then come back, and you can activate your work permit then at the airport. You just cannot go to the States anymore to do that. Okay. Now, if you were traveling to the US for another reason, and you have to be very, very convincing that you're actually traveling to the US for another reason. You can say, oh, I'm visiting my family, I'm visiting, doing it for work. But will the officer actually be convinced if you only go there for a day? Mm, probably not. I mean, you'd have to have a very friendly officer to convince them of this. But technically speaking, flagpoling only includes those people who are going to the border for the purposes of accessing the immigration services, and not because they travel to the US for another reason. You can certainly travel to another country. If you're traveling to another country other than the US, that is not included as flagpoling. Now, here's the kicker though. If you are from a visa requiring country, let's say I'm from India and I have a uh, a work permit, and I need to file another work permit. Okay. Now, or let's say I don't have a work permit. I am from India. It's a visa requiring country, and I need to apply for a work permit. Now, before I could have driven to the US or flown to the US, come back and applied for the work permit at the border because it's a special exemption for people who are only going to the US in the regulations. Now, since they've stopped that, I can no longer fly. Let's say I want to fly back to India or Cuba and then I want to come back. I'm not allowed to do that because visa requiring applicants are not allowed to do that. That's not allowed under the regulations. If I were to have the work permit approved, I first applied to the visa post and have the work permit approved, yes, I can do that. But if I'm from a visa requiring country, I can't travel to another country, come back and apply for the work permit at the airport. If you are from a visa exempt country, let's say I'm from England and I am visa exempt, then yes, technically I could fly to Cuba, fly to England, come back and apply for the work permit at the border as long as I'm not coming from the US. All right. So we have talked a lot about changes and they are very complex and confusing. What should you guys be doing and thinking about right now?
Yeah, first with all the restrictions I think that are in place with LMIAs and eligibility, and also even just thinking about the length of time it takes to get an LMIA and the route of getting an LMIA, certainly the first thing is looking at work permit options that are LMIA exempt. And there are a number of them, but certainly sitting down and thinking, okay, is there a route to a work permit that doesn't involve needing that LMIA? And especially if you fall under one of the low wage LMIA restrictions right now.
Um, when we sit down with our clients, we have not just a plan A, we have plan B, plan C, whatever is possible, because right now we don't know. Nobody really knows. Even the minister doesn't even know because he doesn't even know if he's going to be in office. Likely not, he's going to be in the office. So nobody knows what exactly is going to happen. And the way that the immigration laws are structured right now is that the minister can essentially make these decrees, ministerial instructions, and policy statements without going through parliament. So they can be made very, very fast, and often right before a holiday or Friday of a long weekend. And so what we need to do is A, we can anticipate some things that might be able to happen, and B, we need to make ulterior plans.
And then, of course, thinking right from the beginning what the long term PR options are, right? Certainly from the time that you're starting the work permit application, thinking two steps ahead, not just having your contingency plans, which have become very important right now with every change, like Elizabeth says, but also looking and thinking right from the beginning what your long-term strategy are, what your long-term options are for getting permanent residence, and making sure you're working towards that and making the right decisions from the start so that you're putting yourself in the best position to get PR as soon as possible.
And, now more than ever, the applications have to be perfected. You have to prove every single required factor. And that's always been the case. But we are seeing rejections left, right, and center, oftentimes without reason. But if they have reasons, then, it could be even more difficult because before, sometimes people were getting away with things, especially flagpoling at the border, you're just explaining it to the officer. But now everything's on paper. And the scrutiny is very, very high. So don't try this at home. Don't do it by yourself. This is for professionals to handle. And I can't stress this enough right now. Work permits right now are uh, even with professionals, we are seeing a lot of just weird rejections. And, we are seeing the use of AI for many work permits, especially in the visa posts. We're seeing a lot of um, officers who are not experienced, who are making weird and like bad decisions. And we have to go to federal court. So Zia, you want to go through
Yeah,
what we have to do?
well, I mean, exactly that, right? Even with the most perfect applications, there are certainly situations where officers are still, you're still seeing refusals. And so certainly you have to be prepared to take it to the next step because you don't always know that you have another opportunity to apply again for a work permit or for, study permits, permanent residence, whatever it may be. You have to be ready to take it the next step and take it to federal court to get that decision overturned.
And when we go to federal court, the court does not allow you at that point to submit extra information. The court looks at what was submitted at the time and to see whether or not the officer was reasonable in making the decision. And so a lot of times we see people coming to us where they've tried to do it themselves or with someone, a consultant or someone who is not experienced in this, and we see that there are elements that are missing. In those cases, going to court, you can't just supplement it with additional documentation. A lot of those times we would have to resubmit the application if you have an opportunity to do so. A lot of times, for example, right now with express entry and OIMP and etc., you only get that one opportunity where you're invited to apply. And if you don't perfect the application at that point and there's something wrong with it, even going to federal court may not be enough. So when we prepare the applications, we always have in mind as to if this were to go to federal court, would the court be on our side? Would the court say that if an officer rejected it, that they would be unreasonable? All right. So we're coming up to the questions time. I just wanted to let you guys know if you wanted to book a consultation with us, we'll go through all of your options, whether you're an individual or an employer who wants to help employees or hire new employees. Happy to do so. Please contact us and let us know that you came to this webinar, and we will offer you the discounted rate for webinar attendees. It's only $100 plus tax to come for a consultation, and we'll sit down with you and go over your options. Okay. Also, we are quite active on social media these days. We are posting a lot of updates, a lot of explanations as well. Some of you may have come through our social media. Thanks for attending. And yeah, follow us. These are our links. All right. So let's start taking some questions. We so far have 23 questions. If you have more questions, please feel free to put them into the Q&A button there. All right.
Okay, so I'll get us started here. So for someone who's graduating and is applying for their post-grad work permit,
Mm-hmm.
if they have a low-skilled job offer,
Mm-hmm.
are they still able to apply for the post-grad work permit? And are their children still able to accompany them here in Canada?
Okay. So if you applied for your study permit before November 1st, okay, you're still eligible for a postgrad. You don't have to have a job to get a postgrad work permit. So it doesn't matter what job you're doing. It only matters if your spouse needs to get a spousal work permit. If you don't have a spouse, that's okay. You're still eligible for your postgrad work permit. And your child is fine to apply to extend their study permit. Normally, we will want to see that you have, resources to support your child financially, and they're going to school, and that's still okay, right? Um, Next question, Zia. They're asking if a LMIA can still be processed for high wage for supporting permanent residents.
Yeah, high wage LMIAs are not part of the restriction. That's completely fine. You can apply for high wage LMIAs for both work permits and for permanent residents. Um, the next question here, Elizabeth. So, talking about applying for permanent residence and looking at CRS points, what's the viability of being able to apply for permanent residence through express entry if your CRS points are below 500?
It really depends. We have done other webinars about permanent residents. Maybe we should do another one soon as well. There are different categories that are category-based draws. It depends on your situation whether or not you could qualify for that. Other provincial nominee programs often piggyback on that. So, for example, Ontario has one where they have different categories such as skilled trades. They have a tech draw. They have often invite other people for other positions. They have a French draw, and they could also invite you to apply. And then express entry is not the end all and be all for permanent residents. There are a whole lot of other kinds of permanent residence applications that we could take a look and see if you qualify. So do come and talk to us if your express entry points are below 500 or below, what they're drawing at. I think the last one was 520 something, right? And we can certainly take a look at how you might raise your points or what the chances are in the future for you. Okay, so will the open spousal work permit restrictions apply if their spouse is going to apply for the post-grad work permit after January of this year?
Yeah, so basically the new rules for the family work permits for the spousal open work permits apply depending on when you're submitting the spousal open work permit application. So if it's already been submitted before January 21st, then you follow the old rules. If you're applying on or after January 21st, then you have to follow the new rules. So yes, it would apply. Okay, next question here. Can you do short certificate courses online while you're on a work permit?
Yes, so you don't need a study permit if you are doing distance education. Something 100% online, you can certainly do that. The other thing you don't need a study permit for is you don't need it if you are going to be studying in something less than 6 months. In a program that's less than 6 months, you don't need a study permit for that. So that's fine. Okay, so this person is graduating April 2025, and they are going to be getting a postgrad work permit letter for 6 months. I'm not sure what this provincial postgrad work permit letter for 6 months means. And then they said if until they get their 3-year postgrad work permit, can he extend the work permit of the wife? The wife's work permit expires on July 2025. I've never heard of a provincial postgrad work permit for 6 months. I think
I
it's,
wonder if it's just the work permit letter, the one that you get when
yeah.
you submit just for now when you okay, so when you submit an extension application in Canada or when you're applying for your postgrad work permit, automatically IRCC sends just a standard form letter saying that this individual has applied for an extension and is waiting for a decision and can continue working in Canada. There's an arbitrary date on there. I think it's 120 days from when the application is submitted. Basically, it's just to provide proof that someone can continue working here. Now, with that being said, the date on there doesn't necessarily mean that you have to stop working on that particular date. You have implied or maintained status, and you're able to continue working until a decision is made on that extension application.
Oh,
Now,
they're
going,
talking about the work permit extension
yeah,
letter. Oh, this is
exactly.
our biggest pet peeve on. Okay, right. So you, as Zia has said, you guys know this work WPEXT letter that you guys get, okay, this does not give you status. I have heard all these people say, oh, I have this temporary status based on this letter. No, 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 no. This letter does not give you status. This letter is something that a bureaucrat dreamt up thinking that it would be helpful. It is a double-edged sword. It's helpful on one side because it does help you, get your OHIP extended and you can show your employer. On the other hand, it is extremely confusing and wrong. Okay. On this letter, it says you have status until such and such date. They pick a random date. It used to be 4 months, now it's 6 months. Or until a decision is made, whichever comes first. What that seems to say in plain language to most people is that, oh, you only have status until this date. No, no, no. You have status, like Zia says, until you have a decision, not this random date. This random date means nothing. Okay. You can even go on the IRCC website where you can see that they said, don't worry about this date. Okay. We did this, I did this rant on social media where I explained this, and this really does not mean anything. This letter does not give you status. You get status based on the regulations, based on the law. And you have status until a decision is made, as long as you don't leave the country. Okay. Sorry.
So no, that's definitely passionate about this question. We get it all the time. I mean, I think it's something that it's a really big misconception, and certainly I know a lot of people have the same question. But going back to the second part of this question here, um, how do you extend the work permit of the spouse? Well, again, I think it goes back to everything we've been talking about earlier. The spousal open work permit is dependent on the job that the principal applicant, so the person who holds the post-grad work permit, is working in. Right now, with the new rules, you have to be working either in any tier 0 or 1 occupation or a listed tier 2 and 3 occupation. And the second part to it, and I think this affects a lot of post-grad work permit holders, is that the work permit has to be valid for 16 months. Right. So if you've done a 1-year program and you're getting a 1-year post-grad work permit, then that's going to affect your spouse's eligibility for the spousal open work permit for sure.
Mhm.
Okay, the next question, Elizabeth. When do we apply for the postgrad work permit and the spousal open work permit?
Okay. So, it really depends on your circumstances. Um, your spouse could qualify for the spousal work permit, go through the rules that we talked about, depending on your job offer. Okay. Now, your spouse's work permit is valid for the entire length of their work permit. So sometimes, your study permit, your student status is over 90 days after you finish studying. Okay. And you have to apply for your postgrad work permit. Even though the website says 180 days, I would recommend that you do it within 90 days or when your study permit is still valid, because otherwise you can't start working while waiting for your work permit. And right now, these days, especially since you can't flagpole, that 5 or 6 months while you're waiting for the work permit, it's very important that you start working. Okay, great. You apply for yours. Now, let's say that your spouse's work permit, let's say you graduate in April, and you have until July to apply. But let's say your spouse's work permit is valid until December. Do they have to apply directly together with you? No, not really. They have status until December when their work permit expires. So you could very well apply for their work permit afterwards, especially if you don't have that job offer, that you don't have it yet under your belt. Okay. So do come and talk to us and we can look at timing as to when we can best maximize your chances that your spouse would be eligible for that spousal work permit. All right, Zia, this person said they applied for extension for their study permit before November 1st, included the husband in the extension. Now they're taking another program, a second program, Community Health Service Navigation, which is post-grad work permit eligible, so it's in the field of study. He's working as a permanent sales rep for a construction company for over a year in Sudbury. Will he be eligible to apply for extension when she applies for a post-grad work permit?
So when we talk about occupations, we're not talking about the spouse's occupation, we're talking about the principal applicant. So in this case, the post-grad work permit holder's occupation. So in order for the spouse to be eligible for the spousal open work permit, then we're looking at what occupation the post-grad work permit holder is working in. So that would be what would determine whether or not the spouse can get a spousal open work permit.
And we can also take a look at whether or not your spouse could qualify under the new RCIP program as well, when Sudbury comes out with its new rules, because that could be something where he can also apply for a work permit if he gets past, he gets a community support letter, we apply for permanent residence, and he can also get a work permit based on that. And then you can also get a work permit based on his as well if you don't want to apply for the post-grad work permit. Okay.
Okay, the next question here. Can you explain why the IEC work permit that are being issued after December are no longer eligible for the 50 points?
It's because there are certain provisions that under the regulations qualify for arranged employment. And so when the minister announced that the IC program work permits are going to be issued under another provision, then that provision doesn't fall within the arranged employment points anymore for the regulations. Okay.
So we have a couple minutes left.
Yes. Okay, let's just pick pick a two each and then we can do that. Okay. Um
Okay, I'm seeing a lot of questions, Elizabeth, about how do I know what the best route is for me, whether I qualify for a particular work permit or my spouse qualifies for a spousal open work permit. There's so many changes, and having listened to this, I want to know if it applies to me particularly. What do we do?
Yes, I think in these kind of circumstances, we really need to sit down with you and go over all of your options. It's not something that you can just say, "Oh, well, my friend did this, so I should be able to do it too," right? My situation is exactly the same as them. I can probably I say chances are you are not the same as your friend because your friend would have applied under different regulations, under different situations, and their own circumstances, even though you think is the same, may not be the same. So we really need to sit down with you and go over your situation and offer you a plan. Now, these plans may change as well over time. And that's why, we have a relationship with our clients where we work together with you to go along the path, make sure that we do whatever we can to submit your application in time. These days, I think it's estimated we have around 2.3 million temporary workers, students, temporary residents in Canada, and the government is coming out with less than a tenth of spots for permanent residents under economic categories for people. So a lot of people won't qualify. A lot of people can't. It really depends on you. It depends on a lot of planning, depends on a lot of thought as to whether or not you can maximize your chances of being able to stay in the country, and apply. So it's not just getting permanent residence, it's getting another work permit oftentimes, qualifying for another work permit in order to stay in the country long enough that you might have a chance to get permanent residence. And that's certainly what we are here for. I think we have one uh, last question. A lot of people are asking, how do they book the consultation?
Yeah, so if you send an email in to inquiries@lmlawgroup.com, the email address that's right here on the screen right now, just let us know that you attended this webinar today and that you want to book a consultation, and we'll be in touch to schedule that consultation appointment with you.
All right. Well, thank you all so much for joining us. It's it's always a pleasure to be here with you and talk to you. And thank you so much for all your questions. It times are difficult these days. No denying it. And there's a lot of things going on in the media and the politics, and it's unfortunate that many of you are sort of, caught in this kind of situation. But no matter what, you guys are people that deserve to be in Canada. You have worked so hard to be in Canada and you are good for this country. And I want to encourage you to do whatever you can to try to stay here. We're here for you. We will try to do whatever we can to help you out. All right. Thank you all so much for coming. It's Chinese New Year. Happy New Year. Take care, everyone. Okay. Bye
Thanks,
bye.
everyone. Take care.